The case of our massacre continues as the DSS arraign 5 suspects arrested in connection of the massacre that happens in Owo in 2022. 5 of them appear in the court. Various applications were made for the defense counsel to have access to the suspects. Listen to what prosecution counsel have to say.
We hear there is a fundamental rights enforcement lawsuit against the DSS.
Yes.
Can you clarify on this?
First of all, we have not seen any of the fundamental rights suit. It has not been served on the DSS. It hasn't been served on the DSS. So we didn't come to court because of any fundamental rights suit, as we have not been served of it yet. So I can't comment on it, but we haven't seen such suits, neither have we been served.
So what informed the motion expert team demanding that witnesses should be shielded from public?
Well, as we know, the nature of this matter is a very serious case. So when we have witnesses in such cases, the protection of those witnesses is our paramount concern. So we need to be sure that our witnesses are protected at all costs.
So how many witnesses you plan on calling?
At the moment, we have about 6, but as the case goes on, we'll see whether we need to bring more witnesses.
One more question forward then. Why did you oppose the application for bail?
That's what I'm still saying. You know, when you look at the nature of the offenses that the defendants have been accused of, these people have been accused of belonging to a foreign terrorist organization. Let's protect our country. First of all, we need to be Nigerians before we talk about rights. So when people go about being accused of killing over 40 people that went worshipping, you cannot just allow them to roam the streets. We need to protect our country. That is why we have said they shouldn't be granted bail, because we don't know the length that they may have access to. That's why we have just said no for now. Let them remain in our custody.
But today they have access to a lot of relatives. You are mingling with them. Is that the...
This is the court of law. You can't obviously stop them from talking to their relatives in court. And also, I must make a statement here that has been there's been a misconception that we charge them to court because of a fundamental rights suit. And I'm here to categorically state that that information is false. There is no such fundamental rights suit anywhere. What the DSS has done was to do an intensive investigation. You don't charge people to court without sufficient evidence to sustain those charges. The DG of the DSS, who is a man that values and respects the rule of law, the man has said to the team, make sure that this investigation is being carried out judiciously. Make sure that all the stones are unturned to find out if these people are actually the ones that committed this offense. And for us to have come to court is because we believe we have sufficient evidence to sustain these charges. Other than that, we would have still been doing our investigation. The reason why this matter has been lingering is just because we needed to do a thorough investigation. You don't bring people to court and after coming to court, you now start asking what and what you need to use to support your case. And that is why we have waited this long. And for now that we have come, we believe that we have sufficient evidence to sustain our charges.
Do you think it's appropriate that they didn't meet with their defense counsel until today?
That they didn't meet with the defense counsel?
I think that's an appropriate way to prosecute a case where the defendants can't meet with their lawyer until the day of the trial starting.
Well, like I said, the defendants are being kept for security purposes. This is an issue of national security.
No, but it's their lawyer.
I understand and I agree. We have just been told in court that their application to meet their lawyers have been approved. So they can have access to their... Nobody has stopped them from meeting their lawyers. It's just procedure. You don't just come to the DSS office and have access. There are procedures that must, first of all, take place, and that has been done. So from now on, they can have access to their lawyers.
From now on, but the trial started today.
Yes, and that application was approved this morning. That's the reason why, unfortunately, they couldn't see their lawyer before now. But from now, they can have access to their lawyer, yes.
Also, the defendants have this to say.
Yeah, today, what is the case movements today?
Yeah, as usual, is part of the procedures. we were in court thinking they bring the witnesses, we cross-examine them, we finish with maybe one or two of them. But unfortunately, an ex parte application was brought that they are waiting for a fiat from a learned Sikh, that a Sikh will come to take over the prosecuting team. So it's going to be to lead their team. And that is why the court granted the application, and we equally move our motion on notice for bail, which it was eventually adjourned to 10th of next month for the ruling. That was what happened today.
Are you happy with the procedure?
Oh, of course, yes, we are moving. It's good. If it had been like this since about 3-4 years they've been kept, perhaps we would have finished this case.
So are you sure your clients will be housed free?
Oh, don't let us preempt. Let's leave that to what will eventually happen in court.
You alluded to the fact that you were denied access, but today we saw that access to your clients who have been approved. How do you see this and moving forward?
And you are relating with their relatives?
Anyway, don't let me say it, because now I'm here. Don't let me say anything concerning that. Yeah, we had it in court that it has been approved. But I'll tell you then, let me just keep quiet there. Don't worry about that.
All right. Have you ever been able to meet with them, or how long has this been going on that you haven't been able to meet with your clients?
I've not been able to meet my clients. I've not been able to meet them until last date.
In the entire period?
In the entire years. If I tell you what I went through in this matter, they told me they were in Kainji Dam. I had to travel to Kainji Dam. They were not there. They were kept here. They were kept here.
But their health conditions?
No. That's what I asked them. Are you maltreated? They said no. Oh, I'm so lovely about that. Since they were not tampered. The health, there's a problem. Though according to them, there are good facilities, but they were not given access to it.
Is it not better that now they've approved it, that you put it on record, that it is on the court now they've attested that they've approved it, that you take another trial, not preempting what will happen? That's what we want to understand.
Come again?
I said now they've approved the authorization for you to
visitation.
Yes, so I want you to be on record that now they've confessed to it that they've done it, that you don't preempt what will happen. That
we have seen them today. So except if the family wants to go, then maybe I guide them. But we've seen them. I've asked them the question I want, and they've told me.
They were able to relate with their families. Is that good?
They were so happy. They were so happy. That is the most important thing. They were so happy. They've not seen them for many years.
From Federal High Court, I'm Gbemiga Olamikon for GTV Africa.